Good morning, I'm Vivien Holmes from ANU and welcome to the session now. I'm going to be introducing Professor Richard Moorhead, who holds the Chair of Law and Professional Ethics at University College London. So he's come a long way and we're grateful to him for that. Richard's work focuses on lawyers' ethics, professional competence, the regulation of legal services and access to justice. He's conducted a wide range of empirical studies on legal ethics, so that places him in very good stead to talk to us today about empirical work on lawyers. Richard's also a keen blogger. Having read some of his blogs, I gather he's a Game of Thrones viewer. And I mention this because as Game of Thrones is partly based on medieval history, it shows us a world without the rule of law, a world where those who exert power a world where those with power exert it in any way that serves their interests. I suggest that that type of world is not as alien today as we'd like it to be, and that lawyers have a vital role in keeping it at bay, because in both heroic and very mundane ways, lawyers keep the legal system and the rule of law functioning. But of course, we know that lawyers also sometimes work in more dubious ways and in fact subvert the rule of law and cause harm to the community. Think Mossack Fonseca. So all this points to why it's important to understand lawyers and their role, especially as the profession is, as we've just heard, undergoing rapid change in the face of globalisation and technology. So it's with great pleasure that I hand over to Richard to share with us his insights into what empirical research can contribute to our understanding of lawyers. Richard's going to talk for about 45 minutes and there'll be 15 minutes for questions. Thank you, Richard.
Thank you very much, Julian, Vivian, Murray, ladies and gentlemen. Delighted to make the trip over from dear old Blighty. I'm a food lover as well as somebody who quite likes Games of Thrones, so Melbourne is obviously a good place to come. I was asked to talk about what does empirical research contribute to our understanding of lawyers. I guess in terms of the theme of today, I'm going to be a bit more of the challenge than the opportunities. So keeping with the Game of Thrones theme, some of you may think I'm treacherous and murderous in the way that I describe some of the work on lawyers. It isn't meant to come across like that, but anyway, we'll see how we go. I thought I'd start by saying it's an incredibly interesting but also unnerving time to be studying lawyers, or to be studying legal services, or to be studying services with legal elements to them. It's unnerving because in the marketplace and, for instance, in the world of regulators, the basic concepts, the units of analysis, if you like, are in a process of flux. In sociological terms or political terms, or indeed in economic terms, the ecology of professionalism of lawyers is shifting. And for me, this leaves basic questions open. Who are the lawyers that we should research? The organisations or the individuals? Do we include unregulated providers? McKinsey Friends. I don't know if you have McKinsey Friends, actually, but McKinsey Friends. Or online providers of legal services. Are they lawyers? Are algorithms, expert systems, or legal robots challengers to, or part of, a new cyborg generation of lawyers? Will the Big Four's multidisciplinary professional business service model swallow up what are currently thought of as elite lawyers? I think they might. Will all other kinds of lawyers blend into different kinds of organisation, or blend in with different kinds of technology? That meta-level challenge brings also micro-level challenges. As lawyers blend into different contexts, we see an interpenetration of legal and other logics. The way that lawyers do their work and what they see their work as may be changing, perhaps significantly. The most obvious interpenetration is the Pavlovian need for commercial lawyers to remind themselves and everyone else of their supremely commercial approach. My own work suggests, though, that commercial lawyers both laud being commercial and see in it something of an invitation towards sharp practice, or to corner cutting, or to tolerated unlawfulness. Yet we also found in work on in-house lawyers that some construct the logics of business and profession in ways that suggest a more positive, proactive, and outward notion of, if you like, genuine ethicality. The march of digital into legal spaces is growing apace too. The logics such technologies bring could be really important. The logics of analytical prediction generally and machine learning in particular are quantitative, not qualitative, probabilistic, not analytic, bit-based, not word-based, and as a result, hard to understand, let alone hold accountable or even regulate. And of course, some of these complaints, if you like, are made of law and lawyers generally: complexity, opaqueness, ungovernability even. So it would be ironic and extremist if a good slice of lawyers' dominion were undone, if you like, by hackathons and data scientists. And whilst we should indeed be alert to the problems, like the potentially discriminatory impacts of big data, for instance, every time I hear of the Chicago crime problem, I remember Roger Hood's seminal study of Crown Court sentencing. The failings of big data that we see now were demonstrated by judges back in the 1980s. Judges, or the legal system as it operated then, really did seem to discriminate. Sadly, recent work in my own country suggests the problems remain. But there are other ways in which digital and, if you like, systems-based models challenge lawyer archetypes in litigation in particular, but also when negotiating transactions. Lawyers are on the lookout for differences and arguments, whereas systems designers are on the lookout for solutions that are good enough, simplifications and clusters of data. And an important question is, which is better? Which is better for clients? Which is better for society? Empirical evidence, such as it is, suggests that working with machines may be better than working with large teams of junior lawyers when it comes to e-discovery, for instance. Crucially, I think, when thinking of in systems terms, designers and users must allow for errors. They force the question, if they are thinking lucidly, how inaccurate can our systems be? Machine-based approaches often have to be explicit about risk, or at least some risks. And errors can be tested if their designers have the energy, openness, and skills to do so, or indeed if their clients do. And their clients are, of course, often lawyers. This is much less true of ordinary lawyering with its ideology, if you like, of professional excellence. But in parts of the real world and the machine world, these errors, if they are assessed at all, are assessed behind closed doors. There's a kind of closure. So in sketching out this fluidity and closure, I think there are still a number of opportunities for academic research. There are the big questions, trying to make sense of the changes, to predict trajectories, and foresee some of the problems. There is the very important, I think, opportunity presented by legal practice, particularly newer legal service providers, starting to think in more multidisciplinary terms about legal services. And there are several important strains to thinking digitally about law. The availability of data will increase, and techniques in computational linguistics and machine learning and artificial intelligence are already transforming the way that some researchers have begun to analyze text and talk in law, even perhaps what we might think of as artistry in law. So I'll turn to these themes soon, but return to the central topic. What can empirical research tell us about lawyers? So I thought I'd do sort of a trip through the kind of history of the research that I've been interested in or involved in over the years. And the first big question I remember stumbling across was lawyer and client, who is in charge? Douglas Rosenthal's study of personal injury lawyers in the United States. And in that study, lawyers were carefully classified as either traditional or participatory. The latter, the participatory, worked with their client, and if the client was not exactly in control, the lawyer placed them more centrally at the heart of the case. The traditional were more paternalistic, more controlling. And Rosenthal assessed the way in which lawyers handled the cases and the outcome of those cases, and evidenced, I'm going to try and self-consciously avoid the word proved today, that not only were the traditionalists, if you like, unappealingly paternalistic, they got worse results for their clients. They did more poorly on their cases. Now, I read Rosenthal as an undergraduate. I well remember the sense that serious issues were at stake that might impact on how good a lawyer I would be in the future. It told me also that research could enlighten our judgments. I began to hope that there was a potential for a useful science of lawyering. So let me turn to the next piece of work I want to talk about, which very strongly aligns theoretical, if you like, academic concerns and pragmatic interests. It's a work that had a very strong influence on practice itself, work that told a lucid, I think, compelling story about lawyers. That work is a book called Standing Accused by Mike McConville and others. It was based on many hours of observation and interviews of criminal defence practitioners and their clients in police stations and in the offices and at court. The book articulates two views of criminal defence lawyering. One is of the zealous advocate, investigating and robustly defending clients, the traditional paradigm, if you like. The other is a pragmatist who investigates the client's case and, discovering there is no defence, cuts the best plea deal because that's what the best interests of the client demands. Now, McConville et al.'s discovery was that neither of these views were generally true, neither of them. Criminal defence lawyers typically marginalised their client, treated them as guilty without assessing the evidence, and processed them towards a guilty plea. The zealous white knight or the canny deal maker was replaced by a less competent and, I'm afraid, altogether more cynical machine. Now, it was the level and depth of the information and the stories that the researchers could evidence that made this research so persuasive. It was avowedly qualitative, yet had the heft of time and numbers in the depth of the work. Also, it led to significant interventions in the field. The Law Society and the Legal Aid Board, as it then was, were persuaded to develop the scheme for training and accrediting police station representatives. The Home Office, the government department, was also enlisted in the process, and eventually the scheme was extended to solicitors themselves. It led to, some say, a quite profound culture change within professional practice. Now, such work was part of a long line of studies criticising the operation of the criminal justice system. Similar studies suggested problems in other fields. So Hazel Gen's work on plaintiff personal injury lawyers showed they were rarely the hard bargainers of professional myth. Yet empirical work has also defended lawyers in the broader system. So moral panics about compensation culture or tort-driven defensive medicine have been roundly critiqued. Much has been learnt about charging, billing practices, and the vexed area of settlement. Econometric work has been central to resolving battles in the cost wars between claimant and defendant sides of the industry, whilst also exploring the impact of financial incentives on lawyers' behaviour. Such work is, or should be, I think, central to our understandings of a well-governed law firm or indeed a well-governed legal system. But my favourite personal injury study is a little-known experimental one, which suggests that clients will pay three times more under a no-win, no-fee case than they would under a fixed fee. I like it because it drives me a little crazy in the head. What am I supposed to think of clients who are willing to be charged three times more than they could be, or perhaps even should be, just to transfer the risk of paying? What should I think? Maybe I should just think, okay. Family lawyers, okay, have had a much more mixed set of attention, some positive and some less so. I often wonder, idly and without, I confess, evidence, why this might be. It may be just that family law practice is better quality than crime was, personal injury was. Or it may be that very few lawyers specialise in one side of or the other. So there's less obviously a kind of theoretical proxy for academics to get their teeth into. There's less of an obvious model to critique, maybe. It's the natural function of qualitative studies also to reflect on and develop different positions. Each study is temporally specific and contingent in other ways. Even those on competence have different foci and interests, somewhat different, if you like, theoretical lenses. These studies, though, almost always avert to problems with the lawyerings they study, but the extent to which they emphasize those problems or emphasize the positives that they see is, if you like, through a lens of the writer's choosing. It's much rarer to see a sort of bolder quantification of work done on lawyers more generally. So imagine looking at 100 files and ask yourself what percentage of those files would you accept could be performed at less than competence? What number of files could be, if you like, handled at a level of incompetence? Well, work that Avram Sher, Alan Paterson and I did on legal aid practice did just that. We measured, with the help of expert assessors, expert practitioners, the percentage of cases where lawyers' work dropped below basic levels of competence. The figures. So specialists dropped below acceptable levels about 30% of the time, 30 files out of 100. Generalists, so people who weren't specialising in the area, the figure dropped, the files over 40% dropped below acceptable levels of competence. Horrifying results, even if one accepts a certain arbitrariness in reducing complexities of competence to a number, albeit a number assessed by expert practitioners. Equally, is my 30% failure rate better understood as a 70% pass rate? Both are true. In a recent study of the ethical capacities of new advocates, we got expert assessors again to evaluate the advocates' ability to deal with ethical problems on their feet. What did we find? Well, some were excellent at engaging with the very real challenge of judging, if you like, ethically ambivalent facts. Some could think forward in practical terms as to how their cases would develop and plan the cases accordingly. Some were excellent at applying and balancing competing ethical rules and principles to the facts before them. Now, not enough were good at these, and a substantial minority, the experts said, were poor. But even so, these advocates still wanted more ethics training. They wanted regular practice with ethics problems, and they wanted a culture of engagement in these matters between the senior and the junior members of the bar. In this sense, we saw a kind of glimmer of hope, if you like, empirical research acting as perhaps a catalyst to genuine development. That work's been taken up by the Inns of Court College of Advocacy. So this segue into ethics brings me to a particular shift in methodological and, for me, theoretical interest. Traditionally, our knowledge on lawyers has been shaped by sociological, academics' knowledge, by sociological notions of legal ethics. Work on lawyers' ethics often also has a similar route, albeit with philosophy taking a larger role. Latterly, though, behavioural sciences is garnering increasing interest. So, for instance, Rachel Cahill-O'Callaghan has shown how basic psychological values may be influencing Supreme Court justices when they decide our cases. She and I have done similar work with lawyers. We found reason to doubt, for instance, the claim that zealous advocates are motivated by putting the client first, as it is often claimed. Self-interest appears stronger in those most risk-hungry in the practitioners we looked at. A more extensive look at law students' values, moral awareness, and professional identification suggests female law students have different, frankly, stronger ethical outlooks than male students, and that law students heading into commercial firms show some indications of weaker ethical inclination than other students. This is no surprise, really, given the accentuated emphasis on commerciality in that sphere, perhaps. And an interesting question is whether it combines with the moral relativism that Beth Mertz observed in the first year of law school in the States to create something more worrying. We don't know. It's something which maybe there should be more work on. But before we concentrate more narrowly on lawyers, it's worth remembering that we can perhaps learn rather a lot from other work on regular human beings. So Jennifer Rubinault does a really masterful job of surveying the behavioral literature that might apply to lawyers. So one suggestion is that human decision makers have their thinking influenced by scripts and primes. If lawyers focus too much on billing and profit per equity partner and so on, this may, I would say would, have a tendency to squeeze out, at the margins at least, perhaps more seriously sometimes, ethical decision making. So too does being stressed, being tired, or having too little time to take decisions, as does being competitive, being adversarial, needing to sustain high performance, confronting situations where there is a risk of loss, just falling short, or where one is doing something to help another, to help a client. All of these are associated with a higher risk of unethical decision making. We know too that team loyalty can affect lawyer judgments on lawyer liability and quantum. Subconsciously, lawyers' decisions change when they are told they represent either a claimant or a defendant. Their judgment shifts immediately, interestingly. Take another example. There's research suggesting that an aspirational frame is more ethically dangerous than a compliance frame, a frame that says we should play by the rules. Creative people are more prone to and inclined to rationalization. They are, it's been shown, or there is evidence to support the idea, they're bigger liars. So here I'm thinking of the frame which many of our legal innovators, I think rightly, hold up as essential to transforming access to justice. Now, I'm not accusing Slayton Gordon or Riverview Law, if you guys have heard of Riverview Law, or, God help me, Richard Susskind. You've all heard of Richard Susskind. We had him mentioned several times before. I'm not accusing any of those folks of moral decay, far, far from it. We need to balance risk and opportunity and recontextualize the critiques of behavior that we see in these kind of experimental studies. Sometimes behavioral insights are too broad to be useful. We cannot, for instance, abandon aspiration. We can't give up on it, but we should perhaps be careful not to reify it. So to understand or evaluate ethical tendencies, we need to understand quite a lot about context. We have to recontextualize, if you like, some of those biases that Robin Alt was talking about. Kirkland suggests that for commercial litigators, for instance, ethics only exists at the extremes. My interview-based work with commercial lawyers in private practice and in-house suggests that their notions of professional ethics are actually quite minimalistic, mainly centered on notions of criminal dishonesty. Stephen Vaughan, who I think was out here quite recently, suggests that they have, though, guerrilla exceptions, personal ethical lines which they won't cross. Some won't help, for instance, tobacco companies, will help tobacco companies, but will not help, they say, property developers who are likely to destroy the habitat of gorillas, hence guerrilla exceptions. But let's contrast this with more positive paradigms. So Connolly and Mather in the States suggest IP lawyers have what they think is a probably deserved reputation for being more ethical. And they point to, I think, interestingly, structural, economic, and educational forces at work here. So IP lawyers have a strong specialist external regulator, the Patent and Trademarks Office. They have a small enough community to have the repeat relationships necessary to make reputation important. There is, they tell us, a higher duty of candor on IP lawyers, which, if violated, puts both themselves and their client at greater risk. There is an alignment, if you like, of incentives there. They also tend to be paid in ways which make them less adversarial. And they think, interestingly, because IP lawyers are often trained as scientists, they may respect truth more than Ivy League lawyers. Speculation, I think, but interesting speculation. Nor is the importance of context confined to studies of ethics. So take Griner's controversial, but I think really excellent randomized control trials. These look at unbundling legal services and compare unbundling with full service lawyering. And one of the full service models Griner looks at is successful, he thinks, because the lawyers concerned are experienced, are adversarial, and importantly, are operating in a court system receptive to adversarial assertion of rights. Where lawyers are less experienced or the system is less, and I think this is really important, the system is less adversarial, full legal service was not better than unbundling. So what should we change? Should we change the system of dispute resolution, or should we ensure that there's full representation? Of course, context is not everything. So Christine Parker, Rebecca Nielsen, and Rob Rosen's fascinating study of creative compliance concludes, and because Christine's in the room, I'm going to quote, clients who are committed to compliance hire lawyers to help promote compliance in their organizations. And those clients who are committed to resistance hire lawyers to resist compliance, they found. Our data suggests, though, that to the extent that lawyers influence clients, it is towards game playing, not commitment to compliance or resistance to compliance. Game playing, not compliance. That one sentence, I think, is crucial. Lawyers are fond of suggesting, sometimes, that they merely advise and the client decides, distance themselves from accountability that way. Parker et al. Christine's work shows us that they don't just advise, they sometimes, if you like, lead, and I would say they need to be more accountable for those choices. Sometimes, perhaps, they need to make better choices. Now, this interplay between lawyer and context is at the heart, of our own work on in-house lawyers. Do in-house lawyers really see themselves as cops, counsellors, or entrepreneurs, as Nelson and Nielsen suggested? Or does professional identity matter here? Does one put the client first, or does one adhere to a more independent, Murray was talking about independence earlier, notion of the rule of law or guardianship? Now, nearly all the in-houses we interviewed or surveyed said that they put the client first, nearly all of them. And most, indeed almost all, buy into the idea of commercial awareness, looking for value in business terms when dealing with legal problems. But we also found differences in the emphasis given to other elements of the in-house role. In-houses split, for instance, on whether they thought they should take advantage of uncertainty in law for the client, whether they should look for loopholes and the like. And some were inclined to see, were more inclined to see than others the importance of independence of judgment. Still, too, there was a different emphasis in the extent to which leading in an ethical sense in situations of legal uncertainty, the extent to which that was important to them. Interestingly, too, to me as somebody who studies professional ethics, we found that those lawyers who were more willing to think of decisions in terms of the rule of law, of legality, or the public interest were demonstrably more ethically inclined than those who tended to see things more purely in terms, or more solely in terms, of the client's interest. Importantly also, the more ethically attentive and morally engaged lawyers were those who were operating within a stronger ethical infrastructure. So training and a culture of discussing ethical problems in practice appear to be associated with greater ethicality, although we also found such training and discussion was not very common. So what we've been trying to do there is, through bridging socio-legal concepts and psychometrics, we've been trying to illustrate how the balancing act, this client-public interest balancing act, was being performed and where it was being performed better. Context, character, and capacity, we think, all being important. So let me end this section with research on everybody's favorite human beings, tax advisors. I hope there aren't any in the room now, otherwise I'm going to be even less popular. There's absolutely fascinating work employing what's called it's an adapted version of what's called a defining issues test that assesses the moral reasoning of, in this case, tax professionals. And what they find is tax professionals are not actually bad apples. They do not have generally poorer faculties for moral reasoning than anybody else. But interestingly, when faced with tax problems, their moral faculties, their moral reasoning does diminish. or at least if they are tax practitioners working in private practice, their moral faculties did diminish. Tax advisors working for the Revenue Service, their moral faculties did not diminish with tax problems. Indeed, the moral reasoning scores of tax practitioners in the work context was, and I quote here, well below the level of adults in general and, shock horror, college students. And here's the kicker. They are even much lower than the average scores of, want to guess? Accountants found in other studies. You're probably all married to accountants. You can tell me off over coffee. Let me turn to the digital lawyer, something which I would like to see much more research on. We know a bit about what influences a client to choose digital divorces or wills, for instance, over face-to-face advice from a lawyer. Those who think their cases are relatively simple or their divorce is relatively amicable, and those who are already relatively self-confident online are more likely to use online legal services. So the evidence suggests so far. Interestingly, there is evidence that this does not include, so far, the young. Okay, so very, if you like, tech-savvy group, not very keen to use online advice. Perhaps they're just not very keen to get advice. That's another possibility. The digital divide is not, if you like, likely to be crossed for some, perhaps for many, anytime soon. And assessments of the risks posed by digital practice are not, I'm afraid, so far very deep or plentiful, in spite of, if you like, the regulatory enthusiasm for those kinds of services. Indeed, policymakers are currently sceptical of dealing with risks in this really rather fluid legal services market. So, for instance, again in England and Wales, work on wills fell on the stony ground of the then Lord Chancellor. Stephen Vaughan and Claire Coe's work on independence in large law firms is another interesting example. That evidenced real problems with shadow clients and conflicts of interest in the big firms. But it met with, from the regulator, the prevailing orthodoxies of wanting to minimise, not increase, regulation on lawyers. The SRA, our lead regulator here, thought, and I speculate just a little bit here, that the big firms were better placed to look after themselves than the regulator was to regulate. Now, interestingly, some of those very same firms did not agree. Some wanted intervention. They wanted rules to protect them from their clients, and they saw the research as, if you like, a gateway to that regulation. It was a tactic which failed, but it's interesting nonetheless. Of course, most of you will know that the researcher's relationship to policy can be fraught. The task of giving bad news to policymakers on questions the policymakers think they already know the answers to can be a difficult one. And policymakers, but especially politicians, can spin research findings absurdly. Litigants in person are one of the areas, like mediation, I think, where the central messages of the researchers seem largely the same over the years, and yet they fail to displace the central orthodoxies of those same policymakers. Policymakers pretend mediation solves problems that it doesn't, and they also pretend that litigants in person don't create problems that they do. In these kinds of areas, lessons from research have to be learnt at the margins and saved for a day, if you like, when policymakers may be a bit more rational or have the budgets to deliver more genuine change. Research on entry into the profession is perhaps similar, a case of speaking truth to obdurate power. Qualitative studies on gendering serve to keep the issue in everybody's mind, but this issue was always going to be a long haul. Even Shiner's superb, I think, cohort study of entry into the profession failed to move the needle of progress much. Shiner's team evidenced in, I think, an unsurpassed and clear way how women, BME, and working class students were consistently and sometimes multiply disadvantaged in their search for qualification, yet very little happened. The US, after the JD study, tells us more gender equal sectors in law tend to get paid less. They tell us gender is important to promotion, but surprisingly, perhaps parental status is not. And going to an elite law school produces an earnings advantage that persists over time. A Harvard cohort study, interesting study, found women partners in law firms less likely to be married than men, twice as likely to report having 0 children, more likely to go part-time if they did have children, and reporting more workplace consequences from births, including loss of seniority. The diversity challenge, all the research suggests, is really very serious and a very entrenched one to shift. There are sometimes, though, challenges to a kind of intuitive. We're not really surprised, I don't think, by the diversity findings. Sander and Bambauer claim social class strongly predicts conditions of who goes to law school, but they claim it no longer predicts much about postgraduate outcomes. Law school prestige is important, they say, but it is generally trumped by law school performance, as measured by law school grades. They basically found the people at the very tops of the class, wherever they went to law school, did really well, whatever happened, whatever law school they went to. If they're right, and of course their work's contested, is a firmer emphasis on class ranking in the US law schools context producing less discrimination? It's kind of interesting. Should us Brits contemplate abandoning our cherished 2-1s and first for something more fine-grained? There's a number of social and commercial enterprises now actively contextualizing our students' data to try and improve recruitment and make it more meritocratic and more diverse. Yet it's tempting to ask if law firms really want merit or a more socially laden idea of talent. So here I look at the work by Brian Yackey on the impact of experiential learning on the employment of JD students, again in the States. So this is his basic idea. The basic idea is that by increasing opportunities for skills learning, law schools will produce graduates who are closer to being practice ready, and that law firms will be more likely to hire those graduates than they would have been to hire graduates who pursued, if you like, a more traditional curriculum. Nice idea, right? Law firms hadn't read the memo, though. Status of law schools trumped practice-ready education in his study. Okay. So let me shift then to talk about cyberspace, algorithms, expert systems, legal robots, the things I was talking about at the beginning. What of their impact on the world of research about lawyers? So recent research has predicted the outcome of ECHR judgments, European Court of Human Rights judgments, from computational analysis of the content of those judgments. Dan Katz has used a similar approach to build a model of US Supreme Court decision-making. He updated the paper this week, actually. And Ruger et al. Show how experts predicted Supreme Court decisions, again in the States, rather less well than an algorithm. Ruger et al.'s algorithm has 6 variables in it, 6 really basic variables. Take another study showing a relationship between text, numbers, and ideas. So Adam Feldman's work on the qualities of brief writing before the US Supreme Court. He examines the quality and content of brief writing and its impact on judicial decisions. There are some really interesting findings on experienced lawyers and quality. Experienced lawyers produce better briefs, he thinks, but also on the tone and complexity of briefs, their wordiness, the use of, believe it or not, passive verbs, the deployment of complexity and readability. All of these things predict which briefs are good in the terms that Feldman assessed it, which is basically whether they're adopted by the judges and whether that side wins. The results suggest tantalizing insights both into what influences judges, but also how experienced and, if you like, inexperienced lawyers write for influence. Let me take the computational in another direction. So Anderson and Manns performed textual analysis on about 12,000 public merger contracts in the States. And used research techniques once deployed in genetic research. They trace the genealogy of these agreements. The overall claim is that the process of precedent selection in these mergers and acquisitions is rather improvised, based on haphazard choices. These choices, they think, are made in the rush to get going on a deal rather than as part of a thoughtful calculation about ideal deal structures and contract drafting. Looked at in this way, M&A deal drafting does not look anything like a science, and it has a rather tenuous claim to even be an art. Selection of precedents, they think, is ad hoc, based on convenience and recall of lawyers, not what is in their clients' interests. Very few deals match closely with their precedent, suggesting no standard or core approaches. The lawyers appear to be involved in a relentless chasing of, if you like, their own tails, of making contracts up afresh each time. So here they say this: in the typical drafting process, approximately 22,000 words are deleted or inserted in documents that are typically about, what do you think, 27,000 words long. So 22,000 out of 27,000 word documents getting changed. This, they say, suggests a remarkable level of editorial churning. Whether this is an inefficient or even risky process is the central question the authors pose. Now, practitioners airily dismiss this kind of work without reading it. It's too divorced from their direct experience. Yet I suspect research of this kind will gain a more receptive audience as firms become more genuinely skilled in knowledge management and more genuinely concerned about efficiency, innovation, and what really, really works. You can see, I think, the benefits of engaging with the micro world of lawyers' work product more compellingly, most compellingly perhaps, with Galati and Scott's The 3.5-Minute Transaction. This is a really great book. It's a book on sovereign debt contracts, which is not an area which I would expect to find fascinating, but I really did. The book blends economic and behavioral theory, history and law, qualitative and quantitative data with solid and measured arguments. It's also very readable. The evidence is that very experienced partners in elite firms, New York and London firms, that do sovereign debt work do not understand a key part of their own sovereign debt contracts. Nor did they respond when a court, admittedly an obscure Belgian court, interprets this part of the contract in ways potentially damaging to their clients, potentially seriously damaging to their clients. Two quotes from practitioners interviewed for the book capture the basic line of arguments. This is from one of the experienced partners. You have to understand the system. No one pays that much attention to the minute details like this. One cannot afford to. If one wants to stay competitive, one cannot afford to. The firm has a computer program, one that a junior associate can go to and plug the relevant parameters into, type of issuance, type of issuer, etc., etc. The firm spent a large amount on putting together this system. Associates can now produce a contract for one of these deals in 3.5 minutes. This is the future of contracting in these markets. The second quote's simpler, and it comes from a mid-level associate. This is what they say. Most of what we mark up and send round, they say, we don't understand at all. Now, one of the beauties of the book is the way it ties together a critique of big law business models with practices on the ground. These business models prevent associates from learning their trade and prevent partners from thinking clearly about what they advise on. The lawyers seek to blame their own business models and clients for driving them to be efficient rather than right. One partner is heard to bemoan the fact that they pay associates too much, that they therefore have to ensure they're billed out as much as possible, and that this prevents them spending the necessary time to mentor and train their future partners. It's a catch-22. Context is all, and responsibility is avoided. Now, interestingly, I think, too, this book also serves as a warning for innovators. The first lesson is an obvious one. If you're going to design a system, make sure someone understands that system and keeps an eye on it and fixes it when it goes wrong. Yeah. The second lesson is more interesting, I think. When developing systems, they find a whole variety of complexities and inertias make changing these systems difficult, both within the organizations, within the markets that they're operating, and with clients. Nobody really wants to change these contracts. They like them staying the way they are. Systems which law engages with have a socially constructed or networked inelasticity, at least while those systems remain in the hands of lawyers themselves. That inelasticity is complexity. one more study, and then I'll wrap up with some thoughts. Things going wrong, again, sorry, is the study of the last study, is the subject of the last study I'll concentrate on. It's another great book, Confidence Games, by Tanina Rothstein and Mitt Regan. Through interviews and documentary analysis, they produce a detailed investigation of abusive tax shelters in the US from the mid-90s on for about a decade there. They claim, I think entirely temperately in the circumstances after the evidence they've produced, that law firms, accounting firms, and financial institutions, or at least some law firms, accounting firms, and financial institutions, were involved in the shelter industry, and they say perpetrated fraud, not only on the government, but also on their own clients. They set out a number of factors in the scandals: profit per partner metrics, too good to be true, value billing, the abuse of legal professional privilege, including, interesting to me back home, the extension of privilege to accountants, and the tying up of clients in confidentiality agreements to hide the lawyer's own wrongdoing. Lawyers designed dubious structures and provided pseudo-independent opinions that tax shelters were more likely than not to meet tax rules. The same opinions protected lawyers from liability should things turn sour with the clients. These cookie-cutter opinions were fictions. They were based on facts which did not exist. Opinion givers lacked any semblance of independence and were influenced by their own role in the design of the scheme. So they were designing the scheme and then independently, in quotes, advising on them and collecting hefty fees. One firm became known in the industry as Opinions Are Us. Business imperatives were invented for purely tax-motivated transactions. Aggressive, sometimes rogue tax lawyers were allowed to grow significant practices by firms, sometimes very reputable firms, who lacked either the expertise or the inclination, or both perhaps, given the amount of money rolling into partnership coffers. Okay, so standing back from this partial gallop through some of the research on lawyers, what struck me by way of summary? The first was kind of where I started out, how negative some of this must sound to the practitioners in the audience. The light that these studies shine can feel harsh, but I hope it can also illuminate and pose challenges. It is important to understand the risks and to learn from them. Being challenged, reflecting on those challenges, responding to those challenges is an essential part of modern accountable professionalism, I think. We, as academics, like to think this harshness reflects our critical insight, but it may also reflect the distance between us. Academia and practice are not yet, at least in England, I don't know if it's true here, are not yet good at working together. Researchers, and I might be telling myself this as much as anyone else, need to work hard to build constructive relationships and think about the constructive power of research. But this research can deliver real change. I talked about the criminal defense research. The advocacy research was sponsored by the Advocacy Training Council and has been taken forward by the Inns of Court College of Advocacy. The in-house lawyers research has prompted a serious ongoing discussion with in-house lawyers about what best practice in ethical leadership might look like within in-house legal teams. There is also the important point, I think, that new technologies and multidisciplinary practice provide more positive opportunities for research engagement. Whenever I see Don Philbin's Picture It Settled site, his negotiation aid, I think back to Reifer's work on the science and art in negotiation. That imagined world of a science of negotiation is now realer, if it's not necessarily real. As legal services become more managed, I think, and more multidisciplinary, so those managers become more interested in what works. Firms and the academy have opportunities to learn from each other here, and some are taking that opportunity, although often, I'm afraid, away from the gaze of law schools. Perhaps, too, things like computational linguistics can invigorate law school engagement with text or talk or artistry in law. Perhaps experimental work such as Ellinghaus and Wright's work on codes can invigorate understandings of how rules work. The British Psychological Society suggested that the questions that lawyers typically pose to witnesses about memory often are founded on flawed assumptions. From a truth-seeking perspective, they are bad questions, they think. A science of cross-examination would be a challenge normatively and empirically, but perhaps it should be attempted nonetheless, bit by bit. So, aside from a few obvious things about the merits of specialisation or the importance of context, when asked what we know about lawyers, I feel a bit like one of Kimberly Kirtland's commercial litigators. I feel like saying, you know, there's surprisingly little that is completely, clearly and unambiguously true. There's a lot of things to be contested. It's rare, save in perhaps one or two areas, for research questions about lawyers to receive sustained attention. Studies are not often replicated. Evidence does not really accumulate in real depth. We claim proof more readily than, if you like, we demonstrate wisdom. So I've just told you a story about what research tells us, or really what it tells me, which is just one story, heavily influenced, if you like, by my own interests and experiences. Others today will tell different tales. That leaves me where I have to leave a talk like this, I suppose, with one obvious point, and that point is we need more research. We need much more research. And of course, we need to talk about that research. So at that point, I hand it back to you guys. Thank you very much.
I guess I had a question about these collaborations in settings where the data is not accessible. You know, so we're thinking increasingly about these sort of online forms of dispute resolution and the eBays and Modrias of this world who perhaps are not interested in working with academics and, you know, have their own capability to sort of develop findings of interest to their particular markets. And what sort of strategies do you suggest we employ in that kind of context?
That's a really good question, because I do think the online dispute resolution community is generally pretty closed. There's quite strong commercial interests when you're talking about organisations like Modria. There is a lot of, it really reminds me of mediation sort of 20, 30 years ago. There's a lot of emphasis being put on the online dispute resolution as a sort of, if not a magic bullet, then something that's going to transform civil justice, family justice in some of our jurisdictions. And we have not seen the evidence. What can be done about it? Well, getting regulators more seriously interested, getting the policymakers more seriously interested in scrutinising whether these things seriously work. Some people are really good at thinking of other ways of tackling the research problem. So Christine's study about creative compliance was a really imaginative way of dealing with that problem. There are sometimes ways you can look at these kinds of issues, but beyond those fairly general, bland, if you like, suggestions, I haven't got much more to offer, I'm afraid.
Anyone else? Yes, Angela?
Thank you. Richard, thank you also for the overview. Quite a lot of the research that you discussed was looking at how lawyers currently behave or how lawyers currently interact with their clients. And I think one of the challenges that might be a focal of discussion today is how do lawyers deal with the future, and the focus on what might that short-term or medium-term change look like. It is easier, of course, as a researcher to look at data that already exists. But what are the research challenges for looking at what the future might look like?
Well, so things like online dispute resolution, thinking about how that really works, in what circumstances it does or doesn't work, what makes it effective, doesn't make it effective. I think there's a really big challenge around the use of artificial intelligence, machine learning in legal practice contexts. And I spent a fair bit of time engaging with some of the people who provide in that market. And one of the things that's I think is an interesting question is who really knows what they're doing. If you go and look at the site for Kira Systems, for instance, which is a Canadian machine learning, they do contract analysis software. Noah Weisberg, who I think is the founder of that company, has written a quite interesting series of blog posts around accuracy of the systems and what makes their system accurate or not. And he is comparing Kira's approach to others in the market. And it's quite an interesting, gives quite an interesting little insight into the differences in these systems. And I sort of imagine, but this is again speculation on my part really, that practitioners buying these systems don't have the insight that, if you like, Noah has got into how these systems do or don't work. An interesting question is, what do law firms think they're buying when they're buying these robots or the machine learning that helps with the contract analysis or the e-discovery or, et cetera, et cetera. So I think that's one thing. Another thing is the skills, the knowledge sets that lawyers need to have to be able to run and design these systems, think about these systems. So there are some quite, I think, not terribly interesting debates about whether lawyers ought to learn to code or not. I'm not particularly interested in that. But there are interesting things around what might they need to know to be able to understand systems of advice or systems of legal service delivery. What kinds of knowledge do they need? So those would be the areas that I would be focusing on.
Sorry, yes.
George Beaton. Richard, I'm wondering what your views are on comparative studies in this field. I'm thinking, for example, of the medical profession and the legal profession. What might be learned one from the other by comparative study?
Well, quite a lot. So the tax advisor study, which was partly about light relief in the talk, but there was a serious and interesting issue going on there, which is how are lawyers thinking about their work. That methodology came across from, I think, dentistry, is where it was particularly applied in professional contexts, and then moral psychology is where the tool comes from. So there are those kinds of general lessons. There isn't much interface on the whole between people interested in the professional regulation of doctors and the professional regulation of lawyers, for instance. They all have so I occasionally attend a group which is a sort of group of medical regulators, essentially, and they have exactly the same issues that the legal service regulators have in terms of what works in regulatory terms, and nobody knows, seems to me. So there are lots of things that could be learnt, I think.
Yes.
Follow up on that comment. Sorry, my name's Marie Bismarck. So I have a large NHMRC grant with the 14 health professions in Australia, analysing data on all 620,000 health practitioners in Australia and complaints and disciplinary actions, and now replicating that work with the legal profession in Victoria, so data on all of the registered lawyers in Victoria, so applying the same methodology and drawing out some of the same lessons and learnings. And I agree with you, I think there's a tremendous amount of cross-learning that can occur between those professions.
I think we've got time for one more question. Yes.
So John Richard from the law school. Just from a law school perspective, the things you are talking about, is that on? I'm on. The challenges you've indicated for the professions, to me also suggest there's challenges and for law schools. How do we help prepare students for practice in this environment, particularly in a context where we've got such a tight prescriptive curriculum and these core substantive subjects we have to teach? Where is the room to perhaps equip students with some of these other ways of thinking and skills that they're going to have to acquire to meet these challenges?
Well, I can't really answer the where's the room point for you. We have the same problem, although that problem might be about to abate a bit, we'll see. There is a certain amount that's kind of done extracurricularly, in an extracurricular sense. I do think it is really important to try and get find ways of getting law students to think about these sort of contextual and systemic matters. And of course, some of that can be done in the context of existing courses. Some of it can be done in experiential courses, although maybe they're not going to be so good at getting the jobs if that study is borne out in other contexts. But I do think it's really important. We are going to have to think a bit harder about what is it that law students really ought to know, which is they're going to carry with them, if you like, through practice. I always remember, so I did an experiential clinical course with some theory in it, and there were bits of economics and bits of psychology, other things that I've kind of carried with me the whole of my and I did practice for a while, my whole of my professional life. It was the kind of Rosenthal-y type stuff that I really carried with me, rather than, something about contracts. I can't remember anything about contracts. So I think that sort of thing, we should be looking for ways of making room for that. But it's a really hard to find room, hard to sell it to students sometimes, hard to sell it to firms. Some of them think it's fluffy or not, There's all the problems you'll be familiar with, I think.
All right, we might leave there because we've got another session to go on to, but would you please join me in thanking Richard very much for his very